presenting business for this court. When you hear attention, you shall be heard. May God save the United States of America, state of Florida, and the honorable court. Please be seated.
Good morning, and welcome to this session of oral argument of the 5th District Court of Appeals. It's our pleasure to preside over the cases on the docket for this morning. Let me introduce the panel to you. On my right is Judge Palmer, and on my left is Judge Monaco. And again, I'm Judge Sawaya. An announcement on Nunes versus Nunes. That case has been dismissed and oral argument has been canceled. So I doubt anybody's here on that case, but just in the event that you are, you can leave. So that will leave 4 cases on the docket. And we'll begin with the first case, Swearingen versus State. The criminal cases will have 15 minutes per side for oral argument. The civil cases, 20 minutes per side. We have a clock on the podium that will assist you in keeping time. If the appellant wishes to reserve any time for rebuttal, just let me know and I'll try and assist you with that. If you have any cell phones or electronic devices that may go off during the course of the oral argument, we'd appreciate you turning those off so that we're not disturbed. So with that, we'll begin with Swearingen versus State.
Good morning, Your Honors. May it please the Court. I'm Ron Fox here on behalf of the appellant MARLA Swearingen. And Judge Sawaya, if I could, I'd like to reserve about 3 minutes.
Okay.
Rare is the case where relief will be granted based on fundamental error, and likewise rare is the case where ineffective assistance of trial counsel be addressed on direct appeal. This is one of those rare cases. The case law tries to define fundamental error and gives us some sense of what it's about, how it reaches down to the foundation of the case, equivalent to a denial of due process, goes to the heart of the process, extinguishes the right to fair trial, results in a miscarriage of justice. And all those black letter definitions can be found in many places. The factual applications vary on a case-by-case basis. And the courts, it seems, in my understanding of reading some of the decisions, the courts will conclude, well, this is obviously fundamental error.
Well, what do you think is the principal fundamental error that was made?
Well, I think the definitions really get us to what fundamental error is. Like this proceeding is so fraught with mistakes that nobody can have confidence in the result. That the way it proceeded and was processed makes the court lack faith in the ultimate result. And so therefore, whether objections were made that should have been made or not made, which is much of what's before the court in this case, that has to be resolved by the court, regardless of lack of contemporaneous objection and lack of some other things that maybe ought to have been done that weren't done. And here, it's to me, I still don't know that I can distinguish between those kinds of matters that are reviewable as ineffective assistance of defense counsel on direct appeal or fundamental error. The two concepts seem to dovetail to me.
Well, if he should have objected and he didn't, and the error is bad enough, it's fundamental error and it's ineffective assistance.
And that's
what's the principal error? We're all familiar with what the concepts are. Tell us what you think is what went wrong down there.
Well, I think what went wrong in general, what went wrong here is the prosecution seemed to engage in misconduct that in a variety of ways, which was more often than not totally or inadequately objected to by the defense. So the jury was left with a view, for example, that Ms. Swearingen admitted to the police that she had a gun and shot a gun, but never came to know that she also had reported to the police that she shot the gun up in the air and not at the alleged victim. Now, Ms. Swearingen did testify to that. However, her testifying to that at trial contrast with the officer who first responded not testifying to that, would leave or could leave the jury with the impression that this
But was
is...
the officer allowed to testify that she fired the gun, but left the part out about it being in the air?
Correct.
Yeah.
And it gives the appearance that this is a recent fabrication, or at least you could make that argument. If I were prosecuting Ms. Swearingen, I'd kind of make that argument to say, well, yes, now today at trial she says she shot it up in the air, but there's no evidence that she said that before. Now, the prosecutor didn't go that far, but this sort of evidence would lead to that kind of argument.
Were the statements about shooting the gun and shooting it into the air all part of a single statement? I mean, did she, for example, say, I shot the gun into the air, and they said, well, we can say she said I shot the gun, and cut off the sentence there?
Yes, essentially that's it. Now, I also will acknowledge that there's no real good proffer of that in this record. Although Ms. Swearingen testifies to it, I told the officer I shot in the air, and the defense tries to sort of get to that point by saying to the officer, well, she told you she shot the gun, but she didn't tell you she shot it at the victim, did she? And
Well, he'd already agreed by that point at the motion in limine hearing that it was perfectly okay to say she shot the gun and leave out the rest of it as what, self-serving or something. I forgot what it was.
Correct.
Or no, it was a hearsay objection or something like
that. It was a hearsay objection that was self-serving hearsay objection. That was the basis for excluding that. No reference to the rule of completeness. And
well, was the state's argument on its motion in limine sufficient to set forth what would otherwise come out?
It does refer to, there's some discussion between counsel about, I think defense counsel says, oh, are you talking about someone saying shooting up in the air? There is that kind of a general acknowledgement. And the prosecution says, yes, you can't put somebody, the defense can't put somebody on the stand to say she said she shot up in the air. So it's referred to. The officer doesn't really testify to it on the record, but it's clear. I think it's can be found in the record what the basis of that. My point on the rule of completeness, what the complete statement would have shown had it been allowed to be presented.
What other examples of errors? I know you. I mean, there's a whole list in your brief, but I mean, what would be your next?
Well, I think the two strongest points. One is more of a legal point on the jury not being properly instructed on discharge, possession, and during the course of the crime, and that those things must be proved beyond a reasonable doubt. There was really no instruction about those things, and they enhanced this sentence, or allowed for enhancement of this sentence from what is, in other words, another circumstance, a 5-year maximum to a 20-year minimum. And the jury just had a choice on their verdict form. And the way the jury was instructed on aggravated assault, it said there are 4 elements, and if you find that, you find her guilty of aggravated assault with a firearm. And almost by implication, it seems, if you do that, you must find that she possessed and discharged. Without having those terms defined and without having the jury told they must be proven beyond a reasonable doubt. And I think under the Apprendi kind of line of cases that those enhancing, I don't know if we call them elements or not, but those enhancing features must be alleged and must be proved beyond a reasonable doubt to instill the court with authority to impose that sentence, or with a mandate Judge Singletary thought to impose this sentence. I think the other, the next strongest point, if you will, I think is the prosecutorial misconduct, which I've listed many what I feel are instances of it in my brief. Some of them are more, should I say, outstanding than others, maybe.
What was the worst thing he did?
I think the worst thing might have been when the prosecutor argued in closing argument to the jury. You heard in the 911 tape the victims say the bullet whizzed right past my head. That's nowhere in the record. It's nowhere in the 911 tape. She said that at closing. She said that at sentencing. Another, maybe my next choice, would be...
Isn't that kind of a problem cured by the judge telling the jury to come from the beginning? This isn't evidence, this is argument, you have to remember the evidence. Every time a prosecutor misstates a fact from the evidence, that doesn't create fundamental error, does it?
No. I agree with that. I just think this is the most outrageous incident of it. And another one that kind of goes along that same line, the defendant is testifying and says something to the effect, well, there was this other person out there that day, and this is during the prosecutor's cross-examination. The prosecutor jumps in and says, well, you know what? We talked to that witness, and she said she wasn't out there that day. Now, there was no evidence ever presented of that. And I face the same question you just posed with that, to say, well, but the judge, and I think the state argued that in their brief. Well, the judge told the jury, what the lawyers say is not evidence. But
that wasn't in closing argument, right? That was in the
during the trial.
It was during the trial.
That was actually during the trial that she said that. And also, I think during the testimony of Barry Swearingen, who was the defendant's husband, she said, well, something to the effect, well, your testimony disagrees with every other thing in the trial. And there was some sort of objection to that, and then the prosecutor goes on to say in the presence of the jury, well, I just don't understand that. How this guy's testimony can disagree with everything else, it is incredulous to me. And to me, she's expressing her personal opinion in the believability or reliability of the defendant and the defendant's case. And vouching disparages the defense witnesses and vouches for the credibility of her witness. Samantha Stevens, the state witness, sort of an independent, if you will, witness. The state says in closing, well, Samantha Stevenson, her testimony was just like having a video camera out there. That's vouching for the credibility of her witness. There were misstatements of the law.
Okay, I don't understand that one. If Mrs. Stevenson was an independent witness,
right,
what harm can there possibly be with vouching for an independent witness?
Well, independent's the wrong characterization. She was a state witness. Independent in the sense she was not related to any of the parties, not a participant in it. But whatever function the state witness plays in the presentation of the evidence, for the prosecutor to say, well, this witness was like having a video camera. That's like saying, this is an honest, believable, trustworthy witness, beyond reproach. And
You lost me on that one, I'm afraid.
okay. She goes on to say, the prosecutor, after saying that this witness is like having a video camera out there, she misrepresents what the witness said. She says that Samantha Stevenson saw the defendant point the gun out at the victim across the street. And on cross-examination, she said, no, I didn't really see where the gun was or where the hand was or where it was pointed.
You've got 2.5 minutes left.
All right, thank you very much. Thank you.
May it please the Court, my name is Ann Phillips. I'm here on behalf of the State of Florida. It's the State's position that reversible error did not occur in this case and that any ineffectiveness...
What was the purpose of the motion in limine?
The purpose of the motion...
Concerning the statement that, I fired the gun but was up in the air.
They wanted to keep out any self-serving hearsay.
Well, what was the self-serving hearsay?
about where the gun was pointed, her statement to the police officer.
How does that even make sense to me? Forget the legal niceties. How does that even make sense that the trial judge would allow the statement that I fired the gun, but then leave out the part of the statement in the air? How does that even make sense?
I don't understand that either. It sounded like they were not part and parcel of a single statement. I think under the rule of completeness, otherwise excluded testimony would be allowed.
Wouldn't you agree that it was just plain error for the trial judge to say, okay, you can put part of it in and leave the other part out? I mean, the part out that shows that the gun wasn't even fired at the victim?
Right, but when you look at when they discuss the motion in limine, the quote is, the defense counsel says, okay, I just want to make sure, because I know the alleged victim did make statements initially to law enforcement about where the gun came from and what had happened. I'm still going to be able to ask the officer about that. Right, whatever he saw is fine. Okay, that's fine then. So the testimony about where the gun came from when they went in the house and they found it and that she told them all about it, that seemed to be more what defense counsel was interested in at the time.
Well, I mean, there may be a lot of errors that occurred in this trial that are, attributable to the defense counsel. I'm just trying to make sense out of, a trial judge allowing part of a statement in and leaving out, to me, the most important part, that the gun was fired in the air. Just forget the legal niceties of the rule of completeness and all that. To me, it just makes no sense.
I'm not in the trial court's head, and they did not put any of their reasoning.
Does it make any sense to you?
No, sir.
Okay.
I think if you're going to ask the police officer about what the defendant said to you, you allow in whatever the defendant said to that police officer. The fact that they phrased the question the way they did and that there's no proffer shows that this isn't properly preserved, because we can't tell exactly what was said.
So you agree that it was error, and your argument is simply that it was not preserved and not fundamental?
It was error if the defendant ever actually said that to the police officer. We can't exactly tell what she said. If she just agreed that she fired it.
The error would be in granting the motion, and what the action we're looking at is the trial court granting the motion in limine, saying you can get into this part but not into this part. That's not dependent on what's ultimately said. The court's ruling is either an error or it's not an error. Do you concede that the court's ruling was an error?
I think all of it should have been allowed in, whatever the defendant stated, yes, but we don't know what...
Is that another way of saying it was error?
It could have been, without knowing if the... I'm not trying to be evasive, I know, I'm not trying to be evasive, but if she never made the statement, it couldn't be error for that ruling, for that portion. If she never made that statement, which we simply don't know.
All right. But what you know is what's in the transcript, and based on what was argued to the trial court. Did the trial court err in granting the motion in limine that the state filed?
Self-serving hearsay would not have been a reason to keep that out. That is correct.
So it was error?
Yes, if that statement was made.
The state's motion in limine was to prevent any witness from testifying that the defendant claimed to have fired the shot in the air. That's what
yes.
That was the basis of the motion.
And any witness, including the defendant.
Well, yes, and that was error, and that didn't happen, because the defendant and her husband both testified as to the pistol being fired into the air.
What about the jury instructions? I mean, you heard Mr. Fox explain why he thought the jury instructions, were erroneous. What is your argument?
We didn't. The jury instructions were not really raised as an issue on appeal. The most he started to argue that was in his reply brief in relation to the imposition of the 20-year minimum mandatory, which was raised as a 3800B. So I'm going to argue that that wasn't actually properly presented. But there was no error in the jury instructions, and the 20-year minimum mandatory was properly imposed in this case. The defendant discharged a firearm in the course of committing an aggravated assault. The jury made specific findings. She possessed it. She discharged it. Where it was pointed was irrelevant.
Ms. Phillips, do you see prosecutorial error in the context of this trial?
I do not. I'm not particularly, I don't really like the statement about Ms. Fridley, but I don't believe that was constitutes reversible error such that it reaches down.
Is it prosecutorial error?
It's a prosecutorial error, yes.
But not reversible?
Not reversible error in this context, no. When you look at the way that it was all
What
brought
happens
out.
if you take all the errors that are outlined in the appellant's brief and you combine them all together? Was a fair trial conducted in this case?
Yes, Your Honor, I believe it was. I think when you look at the totality of the evidence and you have an independent witness stating, while she says she couldn't see the gun itself, she saw the defendant's arm straight out. I'm hard-pressed in just reality to figure out how she fired the gun straight up in the air when her arm was straight out. And these are demonstrated, to the jury. She said, no, it was straight out. So when you've got an independent view of this...
Well, even the victim couldn't testify that the gun was fired at him. He said he heard something whiz by his head, but he said that the other individual was so close it could have been him when he responded to the sound. And so even the victim didn't say that the gun was fired at him. He just heard a gunshot, and that was that.
It's still an aggravated assault where she's got a deadly weapon right there at him, showing a proclivity to use it. I think that he is placed in a reasonable fear of imminent harm.
You think it would have been aggravated assault if she just fired it in the air, fired it straight up, fired it in the air? You think that would be a...
Yes, if she's going to show a proclivity to use it, and if somebody's firing a gun near me, I certainly would be in reasonable fear and start to run so that that person doesn't now choose to aim it at me. I think a reasonable fear of imminent harm, there's no warning shot rule for aggravated assault. You don't get to fire a warning shot or I'm going to be really mad and put you in fear. I think the discharge of a weapon near them, I think actually, yeah, that's a reasonable fear.
I was particularly amused by the argument that by shooting the gun straight in the air, the bullet could have gone up and come right back down and hit him.
That is interesting.
You think that's a logical conclusion?
Not in any physics class I took, but that is interesting. But I believe when you view the trial in its totality, that it was a fair trial. The defendant received her due process, and I don't believe that reversible error has been demonstrated in this case. If there is nothing further, the state will lie on its brief and ask you to affirm.
All right, thank you.
Thank you, Your Honors. The matter of the gun being fired in the air and a question from the court, would that be aggravated assault? Under certain circumstances, it could be. Judge Singletary brought up this matter to me in the trial court and said, well, sometimes discharge of a gun alone could constitute an aggravated assault. And as I explained to him, and I'll explain to this court, if somebody's pointing a gun in your direction and you're aware of that and they squeeze off a round, that's an aggravated assault. But if you're facing away from them, you're not aware of any gun whatsoever, and you hear a loud noise, that's not an aggravated assault because you're not put in fear of imminent harm. Now, if you turn around after that and see me standing here with a smoking gun, you may say, well, that could be an aggravated assault. Which leads me to my argument that the 20-year sentence was not appropriate in this case because the discharge must necessarily have occurred before any possible aggravated assault. The only possible basis for an aggravated assault, which I'm not conceding there was any at all, is when...
Well, I didn't hear the state address that issue, and I don't think you addressed it in your main argument, so I don't think that's really proper rebuttal argument.
I'll just rely on my brief as to that point. But going back to the aggravated assault, the discharge of a gun under the circumstances of this case cannot amount to an aggravated assault to an unknowing victim. The Supreme Court has dealt with this issue, a case I cited in my brief, which doesn't come right to the top of my mind now, but it said, firing a gun may, in some cases, be an aggravated assault, and others it may not. And the Supreme Court said an attempted murder, if you're not aware of the attempt, then it's not an aggravated assault. Here, the discharge, Gary Dory heard a loud noise, and it scared the proverbial dog out of him, but he had no idea what that was from.
The jury instructions, according to Ms. Phillips, the argument came in your reply brief, and she says that really wasn't an issue that was properly raised on appeal. I mean, are you just arguing that to show that the sentence wasn't proper?
Well, that's sort of the vehicle that it came to this court with. I filed a motion to correct sentencing error, and in that, as grounds to say the sentence was error, I said the jury was improperly instructed, and the evidence was legally insufficient to support that finding. So it comes to you that way. That may have also been asserted as a ground for ineffective assistance of counsel because there were standard instructions that were not requested.
Okay, thank you both very much.
Thank you.